I appreciate you all taking your time to join me and my partner, Joey Barnett. We're going to provide a general update on the EB-5 Immigrant Investor Program. I will remind you that we will answer questions. Please use the chat function. Please keep your questions, if you may, very short and brief, just like one sentence or so, not these lengthy questions. But if we have time at the end or during the presentation, we will be answering as many questions as we possibly can. So we're going to cover both direct and regional center, with most of the focus on the regional center program. My partner, Joey Barnett, what I call the smart one in the team. I'm very fortunate to have two EB-5 partners, Joey Barnett and Vivian Zhu. Congratulations to you, Joey, on just yesterday, I believe, the EB-5 Investor magazine listed you amongst the top 25. No more rising star. All your work on the IIUSA editorial board. I really enjoyed your recent article. Folks, if you want to understand the process of visa issuance, reserved and unreserved visas, you really want to read Joey's new article explaining all of it. I've read it twice, still don't understand everything, but at least you do, so that's the good news. So,
and congrats to you. You are also recognized by the magazine, specialized field, EB-5 for I don't know how many years now, what, 5, 6, 7 years in a row?
We don't want to give away my age, Joey, but yeah, top 10 specialized knowledge. It kind of sounds like an H-1B formula or something. But anyway, be that as it may, all these badges and honors. But yeah, we do put a lot of time and effort into trying to keep up to date. And we also enjoy trying to keep you all up to date. So thank you for joining us today. And I'm hopeful that we will be able to keep you up to date on all the latest developments. I'll just do the usual legal disclaimer. We're not providing legal advice today. If you do want legal advice, please reach out to us. There's the email address, jbarnett@wolfsdorf.com, bernard@wolfsdorf.com. Feel free to reach out if you've got questions. We welcome hearing from you, positive or otherwise. And please, after this, we are recording this, so we will share this with you all. And feel free to share it with your friends. But remember, this is not legal advice. So let's go over to the basic requirements. This is a little elementary for many of you, I understand. So Joey, no more 500,000. We're now 800,000 with your minimum investment. That amount must be put at risk. We need to keep mentioning that point. People seem to forget that. The money must be at risk, with the framework that only investments at risk are in fact job creating, and that passive investments don't work. That's 800,000 is the reduced amount if you are in a rural area, a high unemployment area, or an infrastructure project. Otherwise, the minimum investment is $1,050,000. So Joey, tell me a little bit about high unemployment. In the old days, we had the TEA concept, and with the TEA concept, there was some gerrymandering was permitted in terms of linking census tracts. We would have the so-called Italian boot. Explain to us how the new high unemployment definition in order to get the reduced amount of 800,000. How does that work? What's the fundamental difference between the old system where you could tie together an unlimited number of census tracts in order to pull yourself at 150% of the unemployment rate? Where are we now, Joey?
Yeah, the new legislation is somewhat consistent with the regs that we had, which have been since vacated, where it's sort of the donut hole, where the contiguous census tracts must touch the census tract in which the project is located. That's the adjacent census tracts. So you can't, have a project located in Manhattan and spring it all the way out to the Bronx or to New Jersey. It really is much more of a limited analysis for high unemployment. And the targeted employment area, that term is still applicable, TEA, and the legislation says a targeted employment area means at the time of the investment, a rural area or an area designated by DHS as a high unemployment area. So that's another big difference, is that before states could individually designate an area as high unemployment and USCIS was to defer to that. Now it's a DHS determination, of course, with the help of an economist and an immigration attorney explaining why it qualifies.
So Joey, most of our cases are still pending after the lapse, the 2019-20 cases, not too many of them. But at the end of the day, they would have filed with a different definition of high unemployment. No problem there, right? They were complying at the time with their so-called Italian boot. Now we have the donut formula, but that's not a problem for the prior projects. It is a problem for any new projects or newly filed petitions, correct?
Correct. The pre-RIA investors are eligible at the time of filing. So any of these new regulatory requirements with regards to minimum investment amount are not applicable to them. When we kind of talk about top-offs or doing new raises to complete old projects, yes, that is obviously something that a regional center and the NCE need to look at very closely, making sure that what was once qualifying as a high unemployment area still qualifies for that lower investment amount at this time.
So we're effectively looking at sort of two sets of laws, as it were, pre-RIA and post-RIA. And we better know both of them, right? Because they're both applicable depending on when you filed the case. That makes a lot of sense. Joey, you touched on the question of top-up. We're hearing that quite a lot. Now, top-up comes up in two contexts. The first one is, there are people going around saying, well, just put 100,000 down and then you can top it up with the other 700,000. We've always been a little bit nervous about that. I know we've taken it on in certain circumstances. Outline the situation where, number one, you would take such a top-up, and give us your views on that, Joey.
Sure. So the first thing that you mentioned is the issue of being actively in the process of investing, which has always been allowed in EB-5. It isn't something that we really like to do, and to be honest, we discourage it, but sometimes it's necessary just based on availability of funding or timing with relation to potential age outs and things like that. But in those analysis or in those types of cases, you have to make an investment in the new commercial enterprise. There has to be some sort of investment, and then you demonstrate where the rest of the funding will be coming from, and you include a declaration pretty much indicating that you will be actively investing the rest of them within a certain amount of time. And that's something that needs to be okayed by the regional center and the new commercial enterprise if you're going through a new commercial regional center project. But really, it comes down to having the full source of funds really identified at the beginning, and not changing that story later on. So we discourage it because changes can happen, and it gives USCIS a second or third chance to look at an investor's source of funds, whereas if you make the full investment and then file, they're really only getting one chance to look at it. So
I think you hit the nail on the head there with the funds need to be identified. And if, for example, you can show that you can't transfer all the money because of currency restrictions, you can only let out so much this year and so much that year, the next year, that might well be permissible. But we actively and strongly encourage people to invest the full amount. You don't want to find out 3 years down the road that your source of funds got rejected. And Joey,
in particular, if you do concurrent filing,
right. If you're doing concurrent filing, you file an adjustment, you're all settled in the U.S., kids are at school, and then you find you get a denial on a source of funds, and you literally caught without any support whatsoever. So, Joey, on this issue of source of funds, generally speaking, the RIA, the new law, basically tightens up, specifically mentioning the requirement for 7 years of tax returns. We often find that a lot of wealthy people in some countries, the tax returns are not that impressive. So how is this impacting your preparation of cases, the requirement that one has to have? Now, the good news, of course, is that gifts are now clearly allowed within, they have to make sense, right? It's not unlimited gifting, but it seems that gifts are formally allowed, certainly within a nuclear family, for example, husband and wife. What about boyfriend, girlfriend? Those gifts allowed?
Yeah, there's nothing in the law restricting who can provide gifts. But the big difference that we see now is in the past, we really only needed to provide source of funds on the actual funds that were gifted. Now there is a records requirement where if there is a giftor or a donor, they are required to provide the past 7 years of their tax returns as well. And that is becoming an issue because a lot of times people don't want to provide such documentation to the U.S. government. So that's where we're seeing that issue.
Yeah. At the end of the day, a lot of giftors, wealthy people, benefactors, aren't that comfortable disclosing all of their resources. So if you are doing a case that involves gifting, just be aware that the giftor has to provide 7 years of.
Yeah, the other big change with source of funds is, in the past, we would not always and provide source of funds for the regional center administrative fee that is paid on top of the EB-5 capital investment. Now the RIA requires there to be source of funds for that administrative costs and fees as well.
Right. So I remember that was in flux. They weren't sure one way or the other. So now the source of funds report is not only for the $800,000, but also for the additional admin fee, which can run $50,000, $60,000, $70,000 and costs. So the government wants to see all of the funds are adequately clean, as it were, and that we show clean money. So staying on with our essential requirements, they're not actually so basic, but the essential requirements. So Joey, now the next issue is this: the comprehensive business plan has always been at the heart of EB-5. The government wants to know, how are you going to do this? How does this investment create these jobs? Remember, this is a jobs creation program, not so much an investment program. The investment must create the jobs, and that is the task of the comprehensive business plan, showing not less than 10 positions for qualifying employees, full-time positions generally, must be created within 2 years. So it's pretty clear that these jobs must be created within 2 years. Joey, help me with this. We just went through some sort of pandemic thing. Can't really remember what it was. But a lot of projects were delayed. Do we see any problem here with jobs being created within 2 years?
Yes. I mean, so the answer is yes or no. It's obviously case specific. But what you have to demonstrate is that the jobs will be created within 2 years, and that 2-year period begins 6 months after the approval of the I-526. That's
Got
what
it.
EB-5 policy states. So there is time after the I-526 is approved before any job creation technically under their policy would need to be created. But what we are seeing is them issuing requests for evidence saying, hey, you submitted this business plan back in 2017, 18, 19, and you said that you were going to be doing X, Y, and Z, and you were going to have 3 to 4 jobs by now. Well, show me that you're executing the business plan. And then it is our responsibility to kind of come back and either provide an updated business plan or show that business activity, show that jobs have already been created, and that it is credible enough to demonstrate that at least 10 full-time positions in the future will be created. So yes, they are picking on that much more, especially with direct EB-5. We're seeing that pretty much in every single direct EB-5 case.
But there is some benefit in the sense that these extensive delayed processing times actually give the project more time to create the job. So at the end of the day, this is one slightly positive circumstance from the delay. So Joey, in the old days, indirect jobs could count for up to 100%. That is finished. Please help us outline what percentage of jobs can now fall within the scope of indirect, which is, for those of you who don't understand regional center, this is it. This is the heart, the brain, the liver, whatever, of EB-5 is the regional center program and the concept of indirect job creation, because quite directly, 10 full-time employees over the period of a project ends up being millions of dollars of investment. So Joey, outline the new rules on indirect jobs and what's permitted.
When you go through a regional center, you're able to count jobs that are created through construction expenditures or operational revenue, and you use these economic multipliers, whether it's RIMS-2 or IMPLAN, to determine the actual job count. Now, what they're saying in the new legislation is that the indirect and induced jobs cannot count for more than 90% of the total job count. That doesn't mean that there needs to be W-2 employees by the project. It just means that there are direct jobs that can be counted within those economic models, and it must count for at least 10%. And if construction is under 2 years, that 90% goes down to 75%. And a couple other differences is that you can now count direct jobs, even if under 24-month construction period, which wasn't allowed before. At least that was our understanding. But there's a great article in the IIUSA Regional Center Business Journal that has a lot of great graphs about why this new job creation restriction isn't actually going to be too tricky to overcome, because based on the geography and the industries for a lot of EB-5 projects are located, that 90% sort of ratio between indirect and direct jobs, the multipliers don't get to that level. So again, this is something that you need to talk with an economist and an immigration attorney who knows their stuff with regards to projects when you're putting together either a new project or you're doing sort of a top off to finalize a raise from an existing EB-5 project, because there's new job creation rules.
Thank you, Joey, for clarifying what is somewhat complicated. You can always read the 100 pages of the new RIA and the guidance, which is sometimes a little bit confusing, or you can listen to Joey and get a very clear idea of how all of this works. So, Joey, while we're on this essential EB-5 requirements, let's talk numbers. The program basically allocates approximately 10,000 visas a year. In fiscal 2021, that ended on September 30th, 2021, we had a double allocation, 19,800 visas. But the tragedy, and it's really a tragedy because of the number of people stuck in backlogs, particularly the Chinese investors. The tragedy of this is that some 15,567, almost 16,000 of the approximately 20,000 got wasted, got dumped, got incinerated. And that is truly a tragedy. I'm not going to get into it right now in any depth other than to say, with 40,000 Chinese waiting in line, incinerating 16,000 visas in 2021 is a terrible thing to have happened. Now, in fiscal 2022, that was fiscal 2022 was the 19,800. Sorry, correct myself. Fiscal 2021, fiscal 2022 was the 19,800 that just ended. Right. So in the
last year, there in fiscal year 2021, I think there were just under 16,000 EB-5 visas that did not get used for EB-5 visa issuance. That's the wasted visas from the previous fiscal year.
From the previous years.
Yeah.
Now, for this fiscal year, we are now in FY 2023, past October 1. The guesstimate for this year is 14,200 visas, if I'm not mistaken. Charlie Oppenheimer's come up with a projection. I haven't seen this officially published yet, but for this fiscal year, which ends of September 2023, the allocation is 14,200 visas, and of that, 32% will be set aside for the new reserved categories. I think, let me just jump to that slide. So in these new reserved categories, we have 20% set aside for rural. We have 10% set aside for unemployment. So the 20% rural set aside will turn out to be, approximately 3,500 visas? Is that more or less 3,400 rural visas?
It's based on the total EB-5 allocation. So when there are more leftovers from the family-based, like there was in fiscal year 2022, it's the 32% of the total EB-5 amount.
But the good news is that the unused reserves from last year carry into this year. So this year, we're going to have pretty much a double or very few of the reserve visas we used last year, realistically. So at the end of the day, the 20% rural allocation from last year most of it is carried into this year, together with what I think is the 10% high unemployment. So we should have a bumper year in terms of reserved visas for FY 2023, so much so that we are now predicting that both China and India will remain current for concurrent filings through at least the first quarter, maybe the second quarter, maybe even to the third quarter of this year. And Joey, there's been a lot of excitement with this new program. And I think most of the action is actually within this specific sphere, in the sense that the Chinese waiting line for unreserved has retrogressed to March 22, 2015. It's disastrous. The unreserved for India is back to November 2019. That's terrible. But in reality, well, it's pretty bad. I mean, it's 3 years. The question is, how fast will it move?
Certainly not as bad as China.
Certainly not as bad as China.
Yeah.
But at the end of the day, for both China and India, which seem to be the two largest countries providing investors, together with Vietnam, of course, is that at the moment, for these folks, there is an extremely valuable and perhaps once in a lifetime opportunity for people to file and capture an early priority date, even if you come from China. So if you F1 OPT or H1B in the United States and you're from China or India, despite the fact that the unreserved categories are so backlogged, there is still this very unique opportunity if you invest in a rural high unemployment or infrastructure project to go straight to the front of the line using these 3 new fast-track express lane visas. I don't think the infrastructure will last very long. I don't know if there are many infrastructure projects on the market, but certainly right now for a Chinese investor, the rural category looks very attractive because we have most of last year's carried over. So 2022 will carry over to 2023. But Joey, this gets confusing. Does 23 carry over to 24 if there's unused?
So, yeah, it does get confusing. And the Department of State is going to have to start keeping tabs on which exact visa numbers they're allocating. But the way that it works is so there were no reserve visa numbers used in fiscal year 2022 because USCIS didn't adjudicate or approve any 526Es that would qualify.
The full quota
of
that double quota that we had, the big whammy 20,000 that I was talking about.
The 32% of that is reserved visas are going to be carried over for reserved visa use in fiscal year 2023.
So Joey, if we're talking about 14,000 plus all those unused reserved, are we actually talking about close to 20,000 again?
Correct.
Wow.
Correct. And if those 6,400,
I think it is.
Yeah, 6,400 that are carried over to the reserve in fiscal year 2023 are not used in that fiscal year, then in the following fiscal year, they go to unreserved.
Wow.
That's how the RIA is written.
So the reserved, the unused reserved will then flip into I get so
unreserved. Yeah,
no, the unreserved categories. Yeah,
correct.
I think we got to all read your article,
yeah,
even though it's about 15 pages long in the
7
IIU.
pages.
7 pages, but it's maths, and lawyers and maths. So anyway, look, here's the bottom line. Let's just keep it simple. At the end of the day, and perhaps this is the reason why we have so much enthusiasm at the moment, is that from the high demand countries and people waiting in line, there are very unique opportunities under RIA. And Congress structured the new law in such a way as to create this new demand. It's a little bit unfair, more than a little bit unfair to the poor folks who've been waiting in line because they're stuck actually moving backwards. Mr. Oppenheimer has indicated that maybe that's just for the start of the fiscal year, and once the Department of State figures out what the actual number usage is, they will advance these numbers. But in the meantime, this is very depressing to see the Chinese final action date retrogress to March 22, 2015, because it's been moving so slowly for so long.
Well, and in particular for those who invested in rural projects, where, the Department of State has pretty much said, well, if you invested in a rural project pre-RIA, you still are not eligible for these 20% reserve visa set-asides.
That seemed really unfair, because at the end of the day, but clearly that was focused on creating new demand and the folks who were stuck in line. So they basically said, and we covered that earlier, the pre-RIA folks are stuck with the pre-RIA law, and these new fast lane set-aside categories only apply to new filings. So Joey, let's do a little bit of a deep dive on the new program. we now have this new 956 form, which existing regional centers have to file by December 29. Many of the regional centers have decided not to continue in business. They've had enough. So tell me, what happens to the 526s that were filed under these old regional centers that decide not to re-up, as it were, and file 956s? Are those guys out of luck?
So this is sort of something that we're waiting for better guidance from USCIS on. I know AILA EB-5 is working diligently on trying to get something from IPO on this. In the settlement agreement, in the Bering case, the terms state that if a regional center didn't file an I-956 by the end of the year, that would not by itself cause associated investors with that regional center to get their petitions denied. That's a little bit inconsistent with what's in the policy manual that was updated post RIA. And so we are trying to get better clarification for that. My thought is to protect existing investors, in particular those who have not obtained conditional permanent residency. We're advising all regional centers to file both that I-956 with that gigantic $17,795 filing fee, as well as the I-956G, which is sort of the replacement for the I-924A that is required at the end of every year. That's what I'm advising all of my regional center clients, in particular those who have investors who haven't obtained CPR status. So
Joey, the 924 is gone. Let's just run through the various 956 forms. We've got the 956, 956G, 956F.
And the H.
And
so the 956 is what you file.
With me, please.
Yeah, the I-956 is what you file for regional center designation, or if you're an existing regional center, you file that with your, as an amendment with your old regional center designation. You have to do that by the end of the year. The I-956F is what you have to file for get project approval. This is sort of the equivalent to an old exemplar filing. And that is required now to be filed before any investor files an I-526E associated with that.
But it doesn't have to be approved, right? At the end
it does
of the
not
day,
have to be approved. It just has to be filed.
Got it.
In both the I-956 and the 956F, you may have to file an I-956H. You probably do. The H talks about the bona fides of those involved with the regional center or the new commercial enterprise or the affiliated job creating entity. This relates to, all of the national security concerns, making sure that they haven't, been involved with fraud in the past. All of the integrity type measures are through that 956H. And then there's the 956G, which is the annual filing that you must do, which is the equivalent to the I.
What's the filing fee on that, Joey?
$3,035.
So, Joey, if I am a British citizen living in London and I sit on the board of a company that's doing a raise using EB-5 capital, do I have to do this 956H and get fingerprinted and go through background checks? Do we know exactly?
When you say you're doing the project, you mean you are a developer?
Yep.
Yeah, technically, yes. I mean, there can be no longer foreign involvement in a regional center, but that doesn't go all the way out to a new commercial enterprise or a JCE.
I just wanted to understand what the scope of that is, because it seems to be a little unclear who has to file the 956H and what sort of contact or association you have to have with the project or the regional center in order to be snared by the 956H.
Yeah, I mean, they seem to be taking a very wide scope, whether you're directly or indirectly involved with the sales or the marketing or the use of funds. We've seen in some requests for evidence that they're taking a very wide range. Pretty much anybody who's listed on the regional center website seems to be required to file one of these I-956Hs.
Well, it is.
Or at least that's what they're saying at this point until there's pushback. Yeah.
Well, it is the Reform and Integrity Act. And as I say, we get about 100 pages of reform and integrity. So quite a lot of information needs to be provided. If people want to be involved, they're going to have to disclose a lot of information about their background. So, Joey, I want to jump into one of the most exciting parts about this. I think probably we could say the most exciting part of the EB-5 program is the concurrent and subsequent filing of an adjustment of status. So let's deal with what I'm going to call a simple scenario. I am not in a backlogged category. So I'm not, I'm from China. My case was filed after March 22, 2015. Or I'm from India, and my case was filed after the current India cutoff date of November 8, 2019. I'm in the United States on an F1 OPT, and the only thing I have is a receipt. So I have a current 526. It is unadjudicated. I'm in the U.S. on F1 OPT. Is there anything stopping me from filing an adjustment of status, getting a work permit approximately 2 to 3 months afterwards? They've got better. Getting an advance parole maybe 6 months after. Is there anything stopping me from filing
I just
an
want to be
adjustment
clear.
of status if
And you're
I'm
saying
in
a
the
visa
US?
is available?
And a visa is available.
No, there's nothing stopping you from doing that, and we're doing that a lot for existing investors who have a visa available. Absolutely.
But what if your 526 is denied? What's going to happen to you?
So when you file for an adjustment of status, we advise our clients to maintain their underlying non-immigrant visa status as well. It's not a requirement, but it's what we advise, because in the event an I-526 were to get denied or the adjustment were to get denied, you would still be able to remain in the United States on that NIV status.
And that could be through no fault of your own, right? I mean, if at the end of the day the project bombs for some reason and the 526 is denied because the jobs were not created or something along those lines, this could be through no fault of your own. The 526 gets denied, and you have cautiously recommended that the person maintain underlying non-immigrant status if possible. So if there was an H-1B option for that F-1 OPT, then they should certainly file for that H-1B just as an insurance policy if the adjustment were to go bad. And let's deal with another scenario. I'm on F-1 OPT, and my OPT just expired. My 12 months of I'm not STEM, my OPT just expired. I am now 3 months out of status, and worse than that, I forgot to stop my employment. So I'm now 3 months out of status with 3 months of unauthorized employment beyond the scope of my EAD. But I happened to bump into an amazing lawyer by the name of Joey Barnett, and I've selected a project. I say, Joey, I've just made my $800,000 investment in this rural project. Can you file an adjustment for me? What's your answer, sir?
So we're going to have to look really closely at those dates, but the answer is most likely yes, because now INA 245K is applicable for EB-5 adjustment of status applicants.
Wow.
And I believe it is and Bernie, correct me if I'm wrong, but isn't that sort of
Since last
considered
entry.
it's from the last entry, but isn't it considered in the aggregate, the 180 days?
No. Since last entry, in the example that I gave you, somebody who's been out of status for 3 months and working during that time is still eligible to file for, that wasn't a trick question.
Okay.
I could have said 2 months out of status with 2 months of unauthorized employment. You don't add the two together. During that 180-day period, the person was out of status. It could be actually 179 days, and you could still file. So let's now...
So the answer to your question is yes, you could file their adjustment after OPT ends, even if you didn't stop working, as long as you filed it before that 180-day period ends.
Thank you. And, that's quite frankly amazing. Now, there's an unanswered question. What if somebody filed pre-RIA? Does 245K work retroactively to the old cases that we filed in 2019 and 20?
That's a great question, and I've heard the answer that they have approved an EB-5 adjustment that based on an I-2 or that would have been subject to 245K for an investor who filed their adjustment before the RIA went into effect. So I would say it is retroactive.
So this is amazing because, if you have like an F1 overstay, now I'm not going to recommend this, but technically speaking, an F1 overstay doesn't trigger the 3 or 10 year bar. So the person could leave, re-enter. If they entered and were inspected and admitted, then they could be eligible to file for adjustment of status. So honestly, putting 245K in here, thank you, Congress. That was a very nice gift for the investors to make sure that people who have relatively minor transgressions, visa overstays, up to 108, I believe it's up to and including 180 days, but don't do that one without checking. So at the end of the day, we have these grace periods now. For
180 days or less.
180 days or less. It is inclusive. I just recently got that one right. So this is amazing. But now, Joey, let's go down the rabbit hole of the 60 and 90-day rule. So Department of State has a rule. Now, this concept of preconceived intent, it's very dangerous because the other word for preconceived intent is misrepresentation, 212A6C, permanent 99-year bar for misrepresentation. And this is one where we are skating on thin ice. And as a lawyer, I have to be conservative. Firstly, remember, if you entered under the visa waiver program, you cannot file an adjustment. So this does not apply to visa waiver entries. That's 30 countries now, most of the countries. But if somebody entered, let's deal with a hypothetical situation. And again, this is not legal advice, folks, because I'm starting to skate on thin ice, but I want to discuss this because it's reality and we have to deal with it. So let's deal with the situation. In the Foreign Affairs Manual, the State Department guidance, it says that a person can use a B visa in order to source and check out an investment. So I come from France, for example, and I have a tourist visa or B1, B2. I'm not using the visa waiver. I come in. I want to check out various different investments. I want to do EB-5. I want to check out some direct investments. I want to look at some franchises. I also want to have a holiday. I want to have a vacation. I need a vacation. And I'm checking out various projects. I'm in the process of traveling through, seeing a few different projects. And I find a good project. And it's taken me 90 days, 3 months to do my due diligence. checking out these projects. I call up Joey Barnett. I say, Joey, look, I found a good project. I just inherited $1 million. I want to do this EB-5 thing. What are my options? Can I file for an adjustment of status in the U.S., file the 526, together with a 485, and stay in the U.S.? If I had no intent, at the time I entered, my sole purpose, well, there were two purposes. One was to have a vacation, and the second one was to source projects and to check out investments. That was the purpose of my entry. Now, 3 months down the road, I call you up, I meet with you in your office, I've decided on a project, I've got the money. Would you file that adjustment, yes or no?
Yes.
Very good. Thank you. And that's the big one. What about another one? I now call you from Paris, and I say, hey, Joey, I'm thinking of doing this concurrent filing thing, and I want to come in on a tourist visa and wait 90 days. Will you then help me file an adjustment? Well, I'm going to answer that one and say no. I don't think we as lawyers can be part of a plan to encourage anybody to enter on a tourist visa with an intent to adjust, because that could very well lead to a misrep finding, even if it's more than 90 days after entry, because those are merely presumptions. The question is, what was your real intent? If I sold my house in Paris, I quit my job, and I came over with this plan, at the end of the day, that intent could really mess up the entire process. Is that your understanding, sir?
Absolutely, and not just this EB-5 process, but any U.S. immigration process in the future. So yeah, it's a huge issue. I just put in the chat a blog that Bernie and I wrote about this a few months back, and I think it's really good because it cites the Foreign Affairs Manual that talks about misrepresentation based on status or conduct after you enter with a visitor visa. It's really important, and we're very conservative on this area.
So Joey, let me go one step further. So I came in on this visa, this B1 visa, and I came in to check out projects. I want to have a green card. I want to do EB-5. And I come into your office and I say, look, but I entered with the intent to file an adjustment. Will you file? Joey says no. So what if the person then says, look, I want to open up a new office of my company and do a new office L1. Or I have a job offer as an H-1B. The H-1B and the L are 100% dual intent visas. So in that situation, even though the person entered on a visitor visa to choose a project, if they were to subsequently get an H or an L, we would have no problem filing the adjustment, because at that point, the entry was based on a full dual intent visa.
Correct.
And
or even entering on an L, as long as you work for the company, or the H, as long as you're working for that company, and then do it immediately afterwards. That also could work. And
in that situation, you don't wait 90 days, right? You would be prepared to file after 2 days. So the person comes in on an H-1B, I would file a concurrent filing within 2 days of entry, because it's a full dual intent visa that is entirely permissible under the H or L. Now, I don't want to spend too much time getting into non-immigrant intent, although obviously we're spending a lot of time on it. For the O1 visa, it's somewhere in between. It's not a full dual intent visa. I would still probably wait at least 60 days. Now, why am I saying 60 days for USCIS? Well, for some reason, USCIS creates the presumption as more generous that 60 days after entry, the presumption then works in your favor. So if you were filing 70 days after entry, that would meet the requirement for USCIS, but it would not meet the requirement for the Department of State. Department of State requires 90 days before they will give you the presumption that you did not enter with the intent to adjust. But at the end of the day, folks, I need to remind everybody, these are presumptions. We also have to look at the facts. So if the person severed their ties back home, sold all their assets, etc., and quit, then, well, maybe even more than 90 days afterwards, even with the presumption in their favor, if the person in fact said yes, but I always plan to come and stay. So this is, quite frankly, one of the best. Joey, what is the current processing time on a 526, sir?
Oh boy, I think it was 58 and a half. Yeah, 58 and a half months for, for 526 or 829?
526.
I think I saw it was 58 and a half for not China, not India. That's based on...
No, wait, we're mixing things up.
Sorry.
57 is the current...
8 to 9 processing times.
Is the current 8 to 9 processing time. 5
That's
years.
what it says online.
I don't even want to ask you the 526 online processing time. It's terrible, right?
Yeah, it's not good, but it's also not consistent with what we're seeing.
So what are you seeing now? Let's be realistic. What are you seeing in terms of your approvals? You're getting approvals almost on a weekly basis. What's coming through at the moment, Joey, on 526s?
Cases that were filed in the end of 2018. It seems like they're stuck on the glut of filings that occurred in December of 2018.
But some 2019 are coming through, right?
Some are coming through, yeah, here and there, but certainly not a big wave. And then we're also getting cases adjudicated that were filed previously with mandamus actions, which the government doesn't...
We'll go into depth on that one in a minute. But what about 829s? What are you seeing coming through on those?
Without mandamus, we're not seeing much adjudications at all. The ones that I have seen recently were filed back in 2016.
Okay, so here's the critical question. Joey, I know you've been filing quite a few mandamus cases. Some of your clients are really frustrated. They want to become U.S. citizens. They want to move on with their lives. They've established roots. They've been here for many years. I'm an immigrant with an EB-5 case. My 829 has now been pending over 3 years. Will you accept that as a mandamus case on the 829?
No doubt, absolutely. The law says that they're supposed to do it within 180 days. Getting InfoPass appointments and the driver's license and the restrictions on travel is a huge headache for folks.
Because you're still only getting the 2-year receipt, right? You're only getting the 24-month receipt.
That is the big catalyst for people who want to do it, on top of just wanting to move on and get naturalization. It's hard to get these InfoPass appointments scheduled. They don't allow you to even try until 30 days before your expiration. And, with travel plans and things like that, it's really aggravating to not have evidence of your lawful status in the United States. And so
which is required, right? At the end of the day, it's required by law, but try and get that stamp and you're within 30 days of travel, or if you're not going to be laid off by they kind of want you as proof that you're going to be laid off your job before they're going to give you what you are required to have. So you're filing more. Let's push you a little bit. What about 2.5 years? Will you file a mandamus on an 829 at 2.5 years?
Yes, I will.
2 years?
2 years, I think. So you have the evidence with the 24-month period, with the 24-month receipt notice. That is right around when I start to say, yeah, you have a really good claim. We have done it for under 2 years as well. And that's we'd have to analyze the specifics of the case. But yes, we've done it we actually just got a case approved it was one of our current clients, great client, but also just frustrated with EB-5 processing. He filed at 13 months. The 829 was pending and we just got that approved.
Wow. Well, I don't want to cause another flood, but I know you have been busy and very successful with the 829s. Let's jump back to the 526s. So
Sure.
my 526 now has been pending more than 3 years. I'm waiting abroad. I'm not going to come in and file an adjustment. I can't quit my life without having the green card in my hand. It's been 3 years. I just can't wait any longer. Would you accept my case as a mandamus case, sir? Maybe
3 years. Look, we're getting a lot of pushback right now.
by pushback, do you mean a motion to dismiss?
We're getting motions to dismiss.
And how many pages will the average MTD be?
Up to 25.
Yeah.
17 to 25 pages. I mean, there is pushback. They'll say, we do have a rule of reason, the visa availability approach. They'll say that you're trying to skip lines of other people who are similarly situated. When you are abroad, you can really only file in the District of DC, unless you can kind of find another way to get venue elsewhere. And in DC, there seems to be the court seemed to have gone on the side of the government with regards to these unreasonable delays. And there's some judges who just, they'll say 3-4 years is not unreasonable. So we have to kind of pick and choose our battles a bit. We have, for cases though that were filed, say by a Vietnamese in 2017, absolutely, I would take that case in a heartbeat. But yes, we are getting pushback for mandamus cases where the I-526 was filed in 2019. Even after we've beaten a motion to dismiss, in the past, the government would just adjudicate. Now they're filing an answer and making us go through a motion for summary judgment. We're trying to do discovery. They're pushing back on it. We're trying to get depositions. And it's a much longer fight. There's no real quick, easy victories for I-526 mandamus if you filed in 2019. It's just not realistic at this point.
So the bottom line is you would consider a mandamus on a 526 when it's over 3 years, depending on the facts, depending on the case, depending on the merits of the case, make sure it's a strong case. And for 829, you might go down as low as 2.5 years. Is that correct?
Yeah, under 2 years for 829.
Under 2 years, great.
Yeah.
Well, thank you. And of course, Joey, that could change, right? I mean, the government could end up fighting you on everything.
Exactly. It's, as I try to say, I forget the standard lawyer line, but past success does not guarantee future results.
That's an investment line, right?
Investment line. But yeah, it's, every case is different, and it's up to the judge. It's up to the U.S. attorney, that both of which are randomly assigned after you file, and the jurisdiction and the case law that they have there. So there are some serious strategic elements that need to be considered before doing mandamus.
So this is pretty complex stuff, right? I mean, it's not, at the end of the day, it's not immigration law 101. You better know your civil rules, civil procedure rules. You better be familiar with the court rules, and you better be ready to face a challenge, because if you file too early, it's not going to be a walk in the park. So checking up our time here and respecting our clients' valuable time, let's jump over to the last confusing issue. In the old days, we finally got to this point of, clients, now they got their green card, or even perhaps before they got their full green card, they file for citizenship. They want to get their money back. And the green card arrives and says, well, I want to get my money back. The first thing we say, well, that's governed by the subscription agreement, right? It's not governed by when you get your green card. It's governed by the documents and the agreement that you entered into with the regional center before you get your money back. So the investment must be sustained. They don't want you to put in the money for 2 weeks, take it out, and get a green card. That's not right. It has to be at risk. Now, there's some confusion here, Joey, and I'm going to ask you to just dive into this confusion? And what are you telling people? I mean, clearly, if you put the money in for only 2 years and then pull it out, are you going to get a green card?
Well, it's something that we need better guidance from. During the stakeholder meeting, somebody asked the question, and the USCIS mics dropped off because they didn't have the answer, apparently, or maybe they just fell off the line. The conservative approach is to stick with what we have been doing since 2017. The investment should be sustained through at least your 2 years of conditional green card status.
Okay, so I'm going to stop you there. At least through the 2 years of your conditional status. So this includes all at the time that the 526 was pending, conditional
Anytime
green card issued, and adding another 2-year period on top of it. So you would not recommend getting the money back prior to the filing of the 829? Ever.
Correct. At this point, it is, I think, yes, that is the advice that I'm giving until we get better guidance from USCIS. Now, there is language in the RIA which suggests that it could be shorter, but we don't know if that was thought through completely.
Seems to be a conflict, right?
Yeah, there's a conflict.
At the end of the day, we've got two different instructions from USCIS, and we don't know which one prevails, so we have to default to the more conservative one, correct?
Exactly. And to be honest, there may not be projects that, the project probably needs the funds for longer than 2 years before they have the ability to repay it as well. So there's sort of the practical aspect of it as well.
Well, Joey, we've been going for about an hour, and I know that most people, concentration, at least mine, doesn't last more than that. I don't know if we have any questions. I haven't really been checking that out. If you can just check that out in the meantime, what do we have? Have we answered all?
I've answered a lot of them, but one that, we have seen a lot of relates to the I-526 is approved and it's sitting and hasn't been moved to NVC or hasn't been scheduled for a final interview. That unfortunately is very common.
So Joey, you've actually been filing mandamus on that very issue.
Yeah, we have.
Because you can't call the NVC anymore.
Correct.
Writing email, you wait a month, you don't get a reply, you follow up another month. That seems like a shame to have to file a mandamus just to move a file from IPO.
Absolutely. It's a ministerial act. There's no reason why it should be taking this long. During COVID, they would say, well, we don't have the people in the office to do it. COVID's over. Everyone else has figured out how to do it. And we have had success with these lawsuits. It is it's a systemic thing. It's not a personal thing. It's happening to a lot of individuals.
So, Joey, we have a question here. We have a gentleman who's on an Italian passport asking whether or not to do an E2 or an EB-5. Look, it's always safer to do an E2 first, right? At the end of the day, create a platform, come into the US, you've got a solid E2 business, get yourself established, and then move to the EB-5. Would you agree with that? I mean, there are two ways to go, but I want to always be a little bit more conservative. Of course, it's a question of cost. But maybe the best thing would be to do an E2 first or go straight for the EB-5. What's your choice? And it may be an issue of timing, right? At the end of the day, if the person's ready to wait 3 years in the home country, maybe the EB-5 is the best option.
Right. I was going to say, if you want to use the E2 to get here quicker, potentially, and that's assuming consulates will quickly accept and adjudicate E2 applications, then you need to make sure that the E2 is structured in a way that can work for EB-5. That's something that is really important to do from the get-go. And it comes
in terms of making sure the correct amount is invested, whether it's the $1,050,000 or $800,000, whether you're in rural, high unemployment, and also, of course, making sure that you do the source of funds. The source of funds report for an E2 is much easier than the source of funds report required for EB-5, right?
Yes, and even more so, making sure that the company agreements are in compliance for EB-5 at-risk requirements.
And the business plan, of course.
And the business plan as well. So yeah, but
it can be done.
It can be done. It also depends on tax liability and what the families.
There you go. The E2,
goals are, so
the E2. Well, we don't want to get into tax now because basically that's very complicated because the E2 is also going to have physical presence test, but of course you have to look at the individual treaties with each one of the countries. But for that person trying to decide E2 or EB-5, very much a timing issue. We are strong supporters of the Regional Center program. The reason why we are strong supporters of the Regional Center program is, quite frankly, that one single point we made, which is the job creation issue, is that with the EB-5 Regional Center, you can count indirect jobs. We have a question on redeployment. There's just a general question. What about redeployment? Well, at the end of the day, the funds have to be redeployed, right? The funds have to be at risk until you have landed in the United States with your conditional green card. Correct, Joey?
Well, and for the 2 years after that.
And the 2 years after.
The big difference now is that redeployment is not limited by the regional center geography. That's the big change with the RIA and redeployment.
So in the previous situation, you had to redeploy within the geographic scope of the regional center. Now you can file an amendment, right, to cover other areas and presumably redeploy in there, or the amendment has to be approved before you can redeploy in the other areas.
Those are two separate. So we're not necessarily amending the regional center's geographic scope so much as we're just allowed now to redeploy outside of their current geographic scope.
In a completely different state, for example?
Correct. That's what's allowed.
So at the end of the day, the redeployment rules have become very generous in scope, at least.
Correct.
Not generous for the investor because they have to remain on the hook at the end of the day.
Correct. There's more options for the regional center and for the new commercial enterprise to find better investment opportunities for, lowering risk and liquidity purposes, things like that, so that when investors finally do reach that 2-year period, hopefully the projects will be in a position to repay the funds then.
Joey, we have a question here about expedited projects. Now, the expedited criteria are relatively clear, but it's been a very controversial issue. Comment on expedited projects, Joey.
Expedited projects must meet the specific criteria, but yes, we have seen certain projects get expedited approvals. We have a client who invested in one of these projects that had received expedited approvals for other I-526s. He filed earlier this year. He already got a request for evidence on the source of funds. He did the actively in the process of investing. We've responded to that RFE already. That case was processing for 6 months only before the RFE. So yes, it is possible. Now, there's always the caveat that just because it was expedited for other I-526s in the same project in the past, that does not guarantee that yours will be. But to date, we've seen that be relatively consistent. And that gets, there's a lot of discussion and confusion with this term priority processing, which is used in the legislation, which is USCIS is allowed to do priority processing for rural projects, but we don't know what that means. They haven't defined the term priority processing. And so right now, it's great marketing for a project located in a rural activity, but we don't really know what that means in terms of USCIS timelines.
Joey, there's a lengthy question here, and I mentioned I'm not really going to get into lengthy questions, but in terms of carryover of unused set-asides, your comment was clear that only rural unused are going to get carried over, not high unemployment or infrastructure. Is that correct?
No, all of them get carried over. It's very clear in the first page of the Act where they talk about carryover unused visas and general availability. They talk about the rural, high unemployment, and infrastructure. All of them are allowed to be carried over.
Which is why this fiscal year, FY 2023, we actually have double, even more than double, in the set-aside category. So we are actually, in the next 12 months, facing a bumper year in terms of visa allocation that would benefit China, India, and Vietnam for new investors at a level that we've never seen before. Because we have last year's quota, we have this year's quota, and for the rural folks, we also have expedited processing. So quite a big bonanza. And then together with the concurrent filing, this is creating not quite a feeding frenzy, but certainly a lot of excitement. Correct?
Absolutely. We've gotten more interest in the past 2 months in EB-5 than we did pretty much in all of 2021 and early 2022 with the lapse. It's really picked up. It's great to see, with EB2, EB3 backlogs in particular for Indian nationals. This is becoming a much more popular way for folks in the United States, either on F1 or H1B, to remain here permanently for their family. And for people abroad, America still is the place where they want to send their kids for education and for their opportunities. And having that green card gives a lot of flexibility. Once you graduate, you don't have to worry about finding, a U.S. employer to sponsor you for your child to remain here. So yeah.
Joey, I'm looking at the time. We're at an hour and 15. I'm going to end with this last question. We have a question from an Indian gentleman. He wants to know, what is the duration for Indian national? It's actually place of birth. Again, if you were to wait abroad, you're looking at least 3 years on a regular 526 filing before you're going to get your interview abroad. If you are in the United States in lawful status, as we discussed, you might be eligible to adjust. If you are on an H or an L, for example, we'd file an adjustment for you tomorrow. You'll get a work permit after about 3 months. You'll get an advance parole approval after, 6 to 9 months, and hopefully you'll get your conditional green card in approximately 3 years. But the big critical issue is that you're able to stay in the U.S., work, and after a period of time, travel. So, folks, I'm going to cut it off at this time. You've got my email address, bernard@wolfsdorf.com. If you've got good things to say, email me. If you've got bad things to say, email Joey Barnett, jbarnett@wolfsdorf.com, or my partner Vivian Zhu, vzhu@wolfsdorf.com. Pardon my weak sense of humor, folks. I hope you've all enjoyed it. The fact that we've only had 2 people drop off in the last hour means somehow I've managed to keep you entertained for an hour. So thank you so much for joining us. We will do this periodically, and I hope you've all learned something today. I got to tell you, I learn every time I do these with Joey. He's the smartest lawyer I've worked with. So thank you,
Thanks,
Joey.
Bernie.
Really
always
appreciate
pleasure.
it. And we are now at the end of our program and look forward to helping you if we can. Thank you so much, everybody. Wishing you a pleasant day.